Right out of the gate, this case isn't just about unpaid rent. It's about alleged criminal activity tied to the property. And in landlord-tenant law, that changes everything. Where safety is on the line, eviction can move fast. So the real question is, how strong is the evidence?
Claim is, Your Honor, under Section 23 of the lease that the landlord may terminate this agreement upon the criminal activity by a tenant, any member of the tenant's household, a guest, or other person under the tenant's control that threatens the safety, health, and the right of peaceful enjoyment of the premises of other residents. There was, whether it was the defendant or whether it was somebody in his household, there was video of a shootout.
Shootout? That's not just a lease violation. That's a potential criminal case overlapping with a civil eviction. And here's the legal twist. The landlord doesn't even need to prove the tenant pulled the trigger, just that the activity is tied to the household. That lowers the bar significantly.
With persons from his household coming out with guns. We attached to our complaint a copy of what we believe the defendant to be walking through the parking structure or through the parking lot with holding a gun. The video showed muzzle flashes from various guns. We'd like to order eviction as soon as possible.
Mr. Hill, what is your position on this?
And just like that, no fight, no denial, no defense. He's already on his way out. But think about it. Was this a strategic retreat to avoid a formal eviction on record? Because that can follow you for years.
I'm moving out. The only reason I'm in here today is to get rid of the furniture in the house.
Okay, so will you be out by next week?
Yeah.
Okay, so do this. You're going to be out, turn your keys into the management office before next Friday, okay? All right. And what I'll do is I'll adjourn the case out to April 24th, 2026 at 12 noon. All right. So try to get all that done before 12 noon, and then likely the case will be dismissed.
Okay.
All right. Thank you.
Okay.
Thank you, Your Honor.
Thank you.
Always
Forrest Knoll versus Khalid Hamad.
Yes, actually, this is Shaima Akrad, his mom.
Pardon?
Good morning, Your Honor. Jillian Engen for
Oh, she's tenant too.
Yes.
All right. All right. I'll need a camera, ma'am. All right. Thank you. No, it's okay. Oh boy, I got two people from the think off. I know,
And we
they're both in.
match.
I know. What's the deal? Is Jim wearing that same color?
No,
never mind.
this is the first time I've been in your courtroom since 2012, Your Honor. So
I know.
Be forgiving and patient, please, as you always are.
Sorry.
I was so happy when I came out and I saw the Zoom screen. I was so happy to see you, but I didn't want to stop and not continue on with the cases. But it's great seeing you. All right. What are we doing on Miss?
Now watch this. This courtroom is moving fast, almost like an eviction assembly line. But each case tells a different story. Some are about violence. Others come down to just a few $100s standing between someone and losing their home.
Akrad's case. What are we doing?
Your Honor, I have a balance including court costs of $632.
All right. And ma'am, how are you intending on getting that paid?
Is that just for the court or is it for the apartment, for the rent?
So I have rent to retain in the amount of $412 plus court costs that were incurred in filing this case for of court costs are $220, but the total that needs to be paid to your landlord in order to stop this case would be $632.
This is one of those critical moments because in many jurisdictions, paying the full balance before the deadline can completely stop the eviction. It's a legal lifeline. Miss it, and the outcome can flip instantly.
Okay, I will take care of that today, actually.
Okay.
You will? Okay. So
Yes.
Here's what I'll do. I'll adjourn it out to next week, the 24th, 2026 at 2 p.m. And ma'am, if you have it all paid, get it all taken care of, this case is going to be dismissed.
Okay, thank you.
Okay? Thank you, ma'am.
Bye-bye.
Have a good weekend.
Thank you, you too.
Forrest Knoll versus Tequila Smith.
Jillian Engen for plaintiff.
Hello,
Hello, what's your name?
Tequila Smith.
All right. What's the claim in this case?
Your Honor, I have a balance including court costs of $701.38.
All right. And Ms. Smith, how were you intending on getting that paid?
I paid it already. I paid it down to 0.
You said you paid it already?
Yep. It's my
When did,
balance is 0 now.
okay, when did you get
They
that
just told
paid?
me to get on here and show y'all the receipt that I paid. At that
Well,
moment, I paid $514 last night because I had already paid on it before they put this court notice in. I just didn't know they put it in.
okay. So you think everything's
But my
paid?
balance is $0 now.
Well, okay, I hear you. But you think everything's paid, correct?
Yep, most definitely.
All right. Then what
Your
I'm going to
Honor.
do is I'm going to adjourn this out to the 24th,
Okay.
2026, 2 p.m. And then if everything's paid and it's truly down to 0, this case is going to be dismissed. Okay, Ms. Smith?
Your Honor.
Okay, thank you.
Oh, excuse me. Hang on a second. I'm sorry, Ms. Engine.
I'm sorry. So I don't see on the ledger that the court costs were added. So those are going to be added to the ledger. Those are 175 total. So Ms. Smith, that will need to be paid in order to get a dismissal on this matter.
Okay, so you said 175?
Yes, ma'am. And I'm gonna let your landlord know that they should put those on the ledger so you can see that there.
Okay, 175. Okay, thank you. I'll try to
Thanks.
get that paid off for the next 4 days.
All right, thank
All
you.
right. Real good. Thank you.
Okay,
Thanks, Your Honor.
thanks.
Okay. Thank you. Is that it for you, Ms. Engine?
Yeah, I'm just gonna hand it over to Alicia now.
Oh, boy.
We're tag teaming today.
Let's see where this goes. All
Yeah.
right. Omar Kareem. I think it is, or Kareem Omar. How'd they put this name in?
It's Kareem Omar. Kareem is the first name.
All right. I don't know why they entered it this way. Versus Ashley Darden.
Alicia Fink on behalf of Mr. Omar.
I'm sorry. Well, the attorney's here. This is a termination case.
Yes, sir. Your Honor, this is a case where there's a criminal matter pending in front of you also.
Yes.
And I don't know if you recall that Mr. Simon is representing Mr. Omar in that matter and that there was something put on the record saying that there was an agreement that we could pursue this at this time, but that possibly the writ of eviction wouldn't issue until that other matter is resolved. And Mr. Simon told me that you have a bench trial scheduled for Monday, the 27th.
Right. And I don't know if that's between that agreement, maybe between the prosecutor and
I think it was just put on the record that the prosecutor wasn't going to hold it against Mr. Omar as any kind of violation of a no contact order.
do you recall that? Okay. Oh, we had a bench conference. I don't know
Yeah.
what was placed on the record.
Maybe nothing was placed on the record. I wasn't there, but my understanding was that this was going to be able to go ahead despite the fact that there's that other matter pending, but that the writ of eviction might have to be delayed.
All right. Then I'll do it this way. Raise your right hand. You solemnly swear from testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God.
I do.
All right. And what is the claim in this case? Seeking to terminate the tenancy pursuant to notice.
Yes, sir. The defendant does not have a lease there and has been living in the apartment with Mr. Omar's permission, but has not moved out despite the requests by him and my office that she do that.
All right. What I will do is I'll grant a judgment for possession, no redemption amount, writ to issue. What is my writ? 17th would be the 27th.
The 27th. So that's the day of the trial. Should we bump it a little after that just in case?
Yeah, that's what I was thinking. Writ to issue the 29th.
Okay.
All right. We'll do it that way. All right. Thank you.
Yeah, it's been a long time. Not since I've seen you, but since I've been in this spot.
Doing that spot. It's great
Yeah.
to see you.
Good to see you too. Take care.
You do the same. Ian Greenlee versus Bridget Martin.
Good morning, Your Honor. David Fantair on behalf of the plaintiff.
And Charles Fletcher. Martin?
Mute.
Oh, there she.
I'm here. Sorry. Gosh.
No, it's okay.
I'm
All
not
right.
used to doing Zoom. Sorry.
It's all right. Okay. Mr. Pantera, what is the claim?
There's rent owing in the amount, including court costs, of $6,183.
All right. And Ms. Martin, how were you intending on getting this paid?
Well, I moved out on November 26th, and Charles Fletcher is refusing to move out, so I don't know what to do. I turned the power off. The power has been off at that apartment since December 2nd. So I don't know what to do.
So you voluntarily surrendered?
My lease was up December 1st and I left.
Gotcha. But he hasn't done that. So here's what I'm going to do. Mr. Pantera, raise your right hand. Do you solemnly swear or affirm testimony regarding the amount that's owed is true to the best of your knowledge, information, and belief?
I do, Your Honor. Would you like me to break down the balance between rent and court costs?
Yes, please, if you could.
It's there's rent of $5,995, court costs of $188 for a total of $6,183. And I will say, Your Honor, that what Ms. Martin is saying, I believe, is true. She has Section 8, and in fact, I think you'll see in the file that we actually started this case with a 30-day notice rather than a 7-day notice, and we got the Section 8 payment through the end of the year, but we didn't get anything for January, so we thought there was an issue. And then when I went to file the case, my client said, and it's a joint and several lease between Ms. Martin and Mr. Fletcher, that she said that she had moved out, and obviously she's taken her voucher somewhere else. But Mr. Fletcher is there, so I had to proceed against both parties.
Here's where things get nuanced. This isn't just about rent anymore. It's about who's actually responsible. When leases are shared, tenants can be held jointly and severally liable, meaning one person's actions or inaction can financially impact the other. But the judge is about to draw a line.
So I understand you want to proceed as to both parties, but Ms. Martin has said she's vacated, and that's actually buttressed by what you're saying regarding the voucher and the payment. So I'm going to allow a default judgment for possession as to defendant 2. I'm going to indicate that defendant 1, Ms. Martin, has indicated she's vacated the premises.
So I will
And
put
I
under
also
further.
have court. Oh, sorry.
I will put under further orders that the case is dismissed as to Ms. Martin, and that the
Yes.
judgment is proceeding with respect to Mr. Fletcher only.
Yes.
So
Definitely.
Ms. Martin, if you've got anything in the apartment that you want, you need to get it out.
Oh, it's been gone since November 26th. I have not been there.
Okay.
Okay, that's what I'm hearing. So, all right,
And
that way you
I
don't.
have text correspondence saying that I was leaving on that day, everything, if you
All
need
right, Miss
any of that.
Martin, Miss Martin,
Yes,
Miss Martin,
sorry.
you're
Yep.
good. No, it's
Okay.
okay. You're good. I'm just doing it in this way so you don't get a judgment as against you.
I appreciate you.
All right. Thank you. You take
Have a
care.
great
For not
day.
knowing for not knowing Zoom, you did a great job.
Thank
right.
you. Have a great day. Bye-bye.
You too. Bye-bye. Mrs. Haverkamp, LLC versus David Frame.
Good morning, Your Honor. David Fantair on behalf of the plaintiff.
And Mr. Frame, you may want to unmute. What is
Thank you, Your Honor.
plaintiff's claim?
The amount of rent that's owed in this case, including court costs, is $2,159.
Mr. Frame, how are you intending on getting that paid?
I would like to address Your Honor, saying that I did it during high school. I had business and criminal law taught by Mrs. Gail Yak, so I do know that the lease contract is, considered to be a contract by both parties, correct, Your Honor? There has been blatant disregard for security and repair in the apartment building that I live in, so I do believe that's blatant negligence. So I'm requesting that to be considered, Your Honor.
All right. So here's what I'm going to do. I'm going to order the defendant to file an answer. You have to file a written answer with the court. I'm going to order that to be filed by the 23rd, 2006, with all of the allegations that you're making. I will then adjourn this matter to the 24th, 2026 at 3 p.m. That is an in-person hearing. You'll need to show up, but the answer needs to be in the court by that time. And you need to make sure that defendant or plaintiff's attorney gets a copy of it.
All right, can I get the court date again, Your Honor? I'm sorry.
The court date is April 24th, 3 p.m. in person.
Your Honor, may I address one more thing?
Yes, you may, Mr. Fenter.
Mr. Frame, we had occasion to go into Mr. Frame's unit in the month of March because there was water coming from his apartment. He had intentionally taken the pipe out from underneath his sink and turned the water on. And so he flooded his apartment and other apartments in the building. And when we tried to address him on that, he made some strange allegations regarding security and stuff like that, that he thinks people were out to get him. Can we order him not to do that again? We can't have floods going into other units because of Mr. Frame's behavior.
Okay, it sounds like that's something that we're going to have to deal with the entirety of that at the next hearing. So, Mr. Frame, get your answer in. We'll see you in a week.
What's the courtroom, sir, Your Honor?
The courtroom?
Yes.
It's courtroom C. You're in the access point. It's the one furthest down the hallway.
Okay, and what I have to bring evidence of, and what would that include? Eyewitness accounts? I don't have a phone or a cell phone.
The first thing you need to do is file an answer to the complaint so I know what your allegations are.
And where would I get that paperwork, Your Honor?
You can fill it out on a general answer form. You can get that from the clerk's office, which is right outside the door of the room you're in.
All right, thank you, Your Honor.
Thank you. Mrs. Haverkamp versus Brandy Daniel.
David Fanter on behalf of the plaintiff. I think there's a second defendant, Your Honor.
There is Allison McPeak. Daniel, you may proceed. Neither are here.
So the amount of rent on this case is $1,420. Court costs of $188 for a total of $1,608. We'd ask for a judgment for possession with a writ after 10 days if that amount remains unpaid.
Judgment to the plaintiff. That's by default for possession. Redemption about any amount requested with a writ issue in 10 days. 103 South Huron LLC versus Joshua Bertram.
Good morning, Your Honor. David Fanter on behalf of the plaintiff.
Mr. Bertram, I think there he is.
Good morning, Your Honor.
Good morning. All right, what is plaintiff's claim?
The amount of rent and court costs in this case is $1,815.
$1,800
and 1815.
1815. All right. Bertram, how are you intending on getting that paid, sir?
I'm going to be picking up a second job. I've lost almost half of my hours, which is a big reduction in my pay. So I've been struggling to pay the rent, and because of what I get paid, I don't qualify for assistance. So I'm going to be working. Have you tried talking to Hawk? Yeah, you have to go through the state of Michigan, and if you get denied from the state of Michigan, the Secretary of State or I can't remember.
DHHS.
Yeah, and then they bust your barriers, or I can't remember.
Yeah.
I've tried it, but I just, because of my pay wage, I don't make. It told me I have to be making $13 an hour to qualify for assistance.
Your Honor, may I?
Yeah.
As you're aware of, there's a new program with MAP, which has a little bit higher numbers than SOS, so I think he should call the SOS because they can refer him over to MAP, or he can just go on the MAP website and fill out an application. And Zachary.
Well, he can do that. Mr. Bertram, what I'm going to suggest you do is call Hawk again.
Okay.
Okay. And there are different programs that are available. So go ahead. What were you going to say?
I was just going to let you know I have been trying really hard. And again, I'm going to be put in several applications for different warehousing jobs. So I would be working from 7 to 3 and then 4 to 11, 7 days a week.
All right. Here's what I'm going to do, sir. I'm going to adjourn this at this point to the 24th, 2026 at 3 p.m. Okay. Why don't you get back on the phone with Hawk see what's there. Now, let me ask you this, and I know things have been tight. Is there anything that you can pay between now and next week?
I literally have $200 in my account right now, and I just got
All right.
paid on Wednesday.
Okay.
Your Honor,
Mr. Bertram,
I've dealt with Mr.
just
Bertram
hold on
before.
to that.
Yeah, I'm okay
And-
with that.
And we'll try to figure it out, but give a call over to Hawk and let's see if we can get you out of this hole and then you can move forward. All right.
Yes, Your Honor.
All right, Mr. Bertram, you take care. Have a good weekend. We'll see you next week.
I'm sorry, can I write down the day that I was supposed to be coming in?
Sure. It's April 24th at 3 p.m.
April 24th, 3 p.m. All right, I'll be there. Thank you.
All right. Thank you. All right.
That's all for me, Your Honor. Thank you.
All right.
I'll submit the two judgments. Have a great day.
You do the same, sir.